Good day, liberators and fellow citizens of the world. I have warned everyone that do not fiddle with the Expropriation Act of 2024 because of the fact that this act is much, much better than the Expropriation Act of 1975 that we have been using since the old regime times. I've said that this new Expropriation Act has got much, much better constitutionally aligned processes in it, irrespective of the fact whether we like expropriation or not. The fact is that, as I've said before, expropriation in South Africa has been with us since 1652. The state always had the authority to expropriate land. I've even said that my family was a victim of expropriation by the old regime already. But no, you rather wanted to go and toy in front of the embassy, and I've warned you that this is going to turn around and nip us all in the butt. And this is exactly what has happened with the DA. People, if you think that the DA is our friend, you have to totally go and reprogram yourself, because what I'm going to expose now about what the DA has done with their so-called Expropriation Act challenge will have to shock everyone. Because in one sense, it's actually expected that this would have happened. But the fact that the DA has somewhat deceived, especially the white Afrikaans-speaking people in this country. You thought that the DA is going to sort out the Expropriation Act problem and we all will sit around a bonfire and sing Kumbaya together. But no, they have actually opened a massive can of worms. And everyone, when they said 3 weeks back that they're going to challenge the Expropriation Act, we all thought, well, it's about no compensation, because the Expropriation Act is intended to whitewash all the white properties and expropriate them left, right, and center. And I've told you that, people, if the ANC, whether we like them or we hate them, if the ANC really wanted to expropriate land without compensation, they could have used the Expropriation Act of 1975. And before I go into this can of worms and this total deceit of the DA, let me just confirm, because there's a massive misunderstanding about what is going on. The Expropriation Act of 2024, the new one, was only gazetted on the 24th of January. It did not come into operation. It will only come into operation once the president has made a proclamation that it will be enacted. So, effectively, the Expropriation Act of 2024, which everyone is now making waves about, is not in power yet. So it does not exist. What does exist is the Expropriation Act of 1975. And what all these toying Afrikaans-speaking people have actually done was that they have awoken a sleeping demon. Because now, with this court challenge, and there's a possibility that it will be successful. And the fact that the 2024 Act has not come into operation yet, we will automatically fall back again to the 1975 Act, which is a total chaos. Why the ANC, if they really wanted to expropriate land without compensation of the white people left, right, and center, did not use the 1975 Act is totally mind-boggling. In accordance with the narrative amongst our white Afrikaans-speaking people. Because, yeah, let me just show you the clip of Helen Zille, what she said. It's a 40-second clip published on the Democratic Alliance website, YouTube site. And listen to what she has got to say.
I've just completed commissioning court papers to challenge the Expropriation Act in court. The DA is fundamentally opposed to the Act in principle, and we have been since 2018, because of the fact that it opens the door to power abuse in taking people's property away without compensation in an open-ended way, which is entirely contrary to what we believe the principles of the Constitution are, and certainly opposed to the DA's policies and principles.
Well, you've heard it from the old lady. What she said was totally deceitful, because once they have announced that they're going to challenge this Expropriation Act, I just sat and wondered, okay, but what is the unconstitutionality about that in terms of how the current 1975 Act, which is now still applicable, is not constitutionally aligned with? Because for all these years, for 31 years, the DA has never bothered to challenge the 1975 Act. But now suddenly with this one that I've explained in detail in other videos are more constitutionally aligned, where one has actually got 3 stages where you can actually challenge the expropriation, whereby the 1975 Act, the current one still in operation, which has not yet been repealed, does not have. There's one decision in the 1975 Act where the minister must just say, I expropriate, and you can only basically challenge the compensation part. But with the current one, you are part of an investigation process whether your property is suitable for expropriation. You can participate in that. Then there is a notice of intention to expropriate, which you can then challenge. And then there is the notice of expropriation to expropriate the property by the minister. And then you can only challenge at that point in time the compensation part. But with the current 1975 Expropriation Act, the minister immediately decides expropriate, and then what will happen is you can lodge a PAJA Act application to the High Court to review the decision that was taken about the expropriation. But effectively, you will only be allowed to challenge the compensation part unless there has been specific processes followed that was not supposed to be there. But let's be frank, if the minister has decided that your farm, your white-owned farm, is in public interest, he can immediately make a decision to expropriate. And the court cannot actually interfere in that process because of the fact that it was an executive decision. And the court usually do not interfere in executive decisions due to the so-called doctrine of separation of powers. But let me just quickly go to the court case of the DA. Once I've learned that they're going to challenge it, and I wanted to know why, I've communicated by email to the leader, Steenhuisen, and also to the head office, to please allow me access to the papers, because I could not have found a so-called Rule 16A notice. You cannot find it. But in any event, I've searched, I've sent them emails way back, longer than a week or so back. They did not respond. I've communicated with the registrar of the High Court. I couldn't find that. They couldn't actually help me much. They did provide me with a case number. So then I've tried to access it. I couldn't access it because I do not have the details of the attorney. I eventually landed up sending Helen Ziller, the old lady, the communication or the email requesting access. And eventually yesterday, I've managed to get access to the court online of this matter. So I've downloaded the notice of motion without there were no annexes to it. And eventually I've got hold, Helen Ziller's office informed me that, okay, I need to go, these are the attorneys, Mrs. Jonker, and I need to communicate with her. She would also give me the papers, and yes, I was supplied with the papers then by the attorney with the annexes. And when I started going through this document, I thought, oh my yolly, what is going on here? And let me just show you what this is all about. Now, the court online cover page, there's the Minister of Public Works and Infrastructure. That's the first respondent, which is Mr. McPherson, a DA member, obviously. Okay. Now, the president, and then there's the chief, the speakers of all the provincial legislatures. So that was strange. Why would they have cited that? And then I started going into the document, okay, the notice of motion, and I just thought, what is going on here? I was totally shocked. Then this is what it says. Then this is the court order. The following final mandates are declared to be inconsistent with the Constitution of the Republic of South Africa 1996 and invalid and reviewed and set aside. The final mandate dated 12 March from the Limpopo Provincial Legislature the final mandate dated 7 March 2024 from the Eastern Cape Provincial Legislature, the final mandate dated 11 March 2024 from the Gauteng Provincial Legislature, and then it goes on for the Mpumalanga Provincial on the 12th of March for the Northern Cape as well. And then they ask, point 2, the Expropriation Act 13 of 2024 is declared to be inconsistent with the Constitution of the Republic of South Africa 1996 and invalid. Okay, that's point 2, but they've got all these other mandates that they want to declare invalid. So I wanted to know the fact that there is no specific detail in the notice of motion what those mandates are about and what it has got to do with the Expropriation Act specifically. So I did not know actually what was going on. But then they asked for the invalidity of the Expropriation Act, the new one. And then point 3, they said, to the extent necessary, the following rules of provincial legislatures are declared to be inconsistent with the Constitution of the Republic of South Africa and invalid and reviewed and set aside. And then they mention here a list of these rules that they refer to. So at this point in time, I was wondering, okay, it does appear as if there was something wrong with the decision-making processes to make this Expropriation Act. And then I had to obviously go over to the founding affidavit by none other than Madam Helen Zille. So this is Helen Zille's, there you see it, Helen Zille. She's of the DA, and then they say that the introduction, this is the introduction. On 20 December, the President of the Republic of South Africa assented to the Expropriation Act of 2024. The Act was promulgated in Government Gazette dated 24th of January 2024. So this is what I've said. So on the 20th of December, the President assented to say that he has signed the bill so that it can become, the bill will then become an act. Okay, so once he has assented to it, then it means that the bill will become the act. Okay, then it goes on, the Expropriation Act is unconstitutional. The application is a very narrow challenge to the unconstitutionality of the Expropriation Act as a whole, alternatively certain of its provisions. Okay, people, what she has said here was that in principle, unlike what she said in this video, they only have a narrow problem with the Expropriation Act. So it's not that the DA had in principle have a problem with the entire Expropriation Act, and they have challenged it way back, according to her, since 2018 or whenever. So now the problem is that, okay, but what are you actually looking at then about the invalidity of the Expropriation Act? But then it goes on that she has now confirmed that the final mandate, which the provincial legislators is supposed to give to their representatives in the National Council of Provinces to vote for the province in a certain way for or against the acceptance of the bill. She has said that those processes for a couple of these provinces have not been followed correctly. So because of that, she says that if even one of them have not followed the correct process, then the ultimate decision making at the end would also be invalid to have approved by the National Council of Provinces to have approved this act. So we are sitting, so immediately I thought, okay, but is this an isolated incident? And I've read the entire founding affidavit of Mrs. Zille, and there's no indication that this has also happened in all other legislation as well. She has opened a can of worms that the DA was aware of the fact that the legislative processes in South Africa are not on par. So they have conveniently taken the Expropriation Act of 2024 to put this in and challenge this whole entire decision-making processes where final mandates are given to the representatives of at the National Council of Provinces, but there's no indication that she has said that this is not applicable in other legislation as well. So suddenly out of the and what you must note here is that those decisions have taken place in March 2024. It's almost a year ago. So what has the DA done to fight those invalid decisions that were taken in the provincial legislators? There's no indication whatsoever in their papers that they have challenged that to say that, sorry, you are not supposed to do this. And there's no indication in her affidavit that they have tried to stop the entire process much earlier. They've allowed the DA and most probably other political parties, knowing or should have known this, what they have now revealed, should have known that there was a major problem with the decision-making process, but they've kept quiet. Because why did they keep quiet? Because if they would have suddenly exposed this in the way that the DA did, and the DA is not coming for, I will explain why I believe that the DA is not our friend and hero to suddenly expose this. I will get to that now. But the fact is that all the other parties should have known this. And this would have been a practice because the rules and everything have been the same for a long time. So all the bills that have been approved, the Ballot Act bill, the extension of agricultural land and what have you, BEE, what? All of them would have faced the same fate at the end of the day. So let me just quickly show you a clip of what Mr. Willie Oukamp, the national spokesperson of the DA, said.
Well, firstly, we've had a lot of procedural problems with the signing and the processes that this bill followed. In the NCOP process, there must be provincial mandates that must be obtained. Those mandates must be obtained after sufficient consultation with the public has been done. Unfortunately, that did not happen in the NCOP process here. There's a number of provinces that did not do proper public consultation and that did not have a proper provincial mandate on this. The Northwest province did not provide a mandate at all. The Western Cape, where the DA governs, obviously voted against this bill. So there are only 4 provinces. If you look at the fact that Limpopo, the Eastern Cape and Gauteng had flawed processes, there are only 4 provinces that voted in favor of this bill. And you need to have a majority. So that is one of the procedural problems that we've got.
So he has explained now that what I've just said was, yes, they had a problem with that. And apparently Mr. Macpherson, the DA Minister of Public Works and Infrastructure, have written to the President about this, and yet the President continued to accent to the Act and also to that the Act was then published in the Government Gazette. But they do not attach that specific letter that was sent to the court papers. That's not given. And also, there's no confirmatory affidavit or whatever from the Minister of Public Works because he has been put in as the respondent. So what the DA has effectively done here, this is nothing. I will come quickly get to the part of their challenge of the Expropriation Act, the left hook uppercutter that they've got against the Expropriation Act, which is totally pathetic to say the least. But now Mr. Macpherson is a respondent. So what the DA is actually doing, this has got nothing to do with the Expropriation Act, people. What they are actually doing is they are holding the government at ransom. Obviously, none of them have anticipated that Liberty Fighters Network would have actually obtained that document. So I have gone out of my way to get that because I wanted to know what was going on, and I've eventually managed to get it. And now I've seen the nemesis of the government and political parties like, above others, the DA, has now seen what I was not supposed to see. And now I'm sharing this information with the entire public so that everyone can know what our government has been doing. Our parliamentarians, our representatives to parliament have totally let us down. To go into the scan of worms, to actually go and establish how many legislation have gone this route is totally amazed. But what the DA has done is that they've put a gun against the head of government to say, okay, if you are not going, if you, Mr. President, are going to accede to this act, then we're going to do this, and then it will have repercussions which we are going to take forward now. Because I want to know which other laws have been affected. The Ballot Act, whatever. I want to know. Now, what they do is, so they put in the President of South Africa in a very uncomfortable position, knowing well that this is going to backwash. The floodgates will open, and Liberty Fighters Network has opened the floodgates now. So he's concerned, and they're concerned, to hold a pistol against the head of the President, not to sign and to enact or to make the Expropriation Act to bring it into power. And why would the DA want to do that? Why would they want to stop the signing of the Expropriation Act? Is because now, as I've said, we have awoken a sleeping demon. Because now, up till the time, the president will most probably not sign it into law now, to sign it off to become operational, pending the outcome of this court case of the DA. So what will happen is that, okay, the ANC will say, now that you don't want to go for the nice Expropriation Act of 2024, we are going to open the floodgates to expropriate under the 1975 Act. Oh my God, what? I fear every one of you Afrikaans white-speaking groups who have toyed and said, thank you, Trump, we love you, please stop this. You have opened this massive gap, and I see red lights all over now. Let me just get to the expropriation part before this video becomes too long and you're just going to switch off, not registering actually what I have just revealed to you. When you go over to the their left hook uppercutter, as I've said, is that they think that Section 19 is unconstitutional. Oh, gosh. Section 19. Let me just go to Section 19. Section 19 says that, let me just get to that point, Section 19. And when I read this, I thought, is this really what your best hook on the Expropriation Act is? Your low-hanging fruit that you are talking about, Helen Zille, in other communication? If the Expropriation Authority and the disputing party do not agree on the amount, time and manner of payment of compensation, they may attempt to settle the dispute by mediation, which must be initiated and finalized without undue delay by either party. And then, if the expropriating authority and disputing party do not settle the dispute by consensus or mediation, either party may, within 180 days of the date of the notice of expropriation, institute proceedings in a competent court for the court to decide or approve the amount, time and manner of payment of just and equitable compensation. Now, so their big concern is that the 180 days given is not enough. That's totally irrational to lodge this application. But they do not say anything about the fact that there's an investigation process where the owner can participate in. They do not say that there's an intent to expropriate notice, which can also be challenged, and then there is an expropriation notice which only determines the compensation, then expropriation has taken place. What they are saying in their papers is that they are basically saying that well, if the compensation has not been dealt with, there cannot be expropriation. No, you do not understand how expropriation has been working since 1652 in South Africa, Mrs. Helen Zille and the DA party. Because if you have known how expropriation actually works, is that when there's a decision by the minister, it's expropriated, whether you like it or not. That is how expropriation on behalf of the state has always worked and operated. So by the time you get to the third hurdle and you have just sit back, the 180 days is more than enough to have, because you already had a very, very, very long time before then to have stopped everything. And if you have just waited, like the DA has now done, they've waited for almost a year to actually stop this act. But they have just sat there and, okay, at that point when it's signed, then we're going to hold a pistol against Ramkat, the president. So, people, let me just show you what the current 1975 Expropriation Act actually now says. They have complained about the 180 days, but until this whole court case has not been finalized, which can be a year or 2 or 3, and the president can most probably say that, okay, let's just, I will not sign it off until this has been dealt with. The Expropriation Act in Section 10(5)(a) says that unless the minister and the owner have agreed otherwise, the latter shall be deemed to have accepted an offer made to him by the minister in terms of subsection 1, 2, or 4, if he fails to make an appropriate application to a court referred to in Section 41 for the determination of the compensation before the date determined by the minister by written notice addressed to him. So it means that the minister, when he decides that I want to expropriate your land, it now belongs to the state, we are going to utilize this. By that time, he can just in his notice say that you've got 7 days, you've got 30 days, you've got 6 months, whatever the minister feels at that stage, because he is authorized by law to do this. By this act, he is authorized to determine 7 days. I want to make 7 days, and that is the date. The court cannot interfere with that because it's an executive decision, and in terms of the doctrine of separation of powers, the court has extremely limited authority to interfere with that decision. Now, while we are waiting for this much better Expropriation Act of 2024 to come into operation, now the minister, who's going to be Mr. McPherson, if the DA is going to stay in the government of national unity, which is now threatened that they're going to withdraw, and then Mr. McPherson will not be the Minister of Public Works and Infrastructure anymore, and there will be an ANC or an EFF or an NK or a whoever minister there who's going to, as I've said, open the floodgates. People, I am so sorry that I'm the bearer of extremely bad news, but when you poo on your own stoop, you will step in it. And do not wake up sleeping dogs as you have done with all your toy-toying and demekaarheid. You have now actually contributed to this mess we are now in. Liberty Fighters Network will now intervene physically in this court case to ensure that the truth is revealed and that the protection that we can still have is very much limited. Alternatively, we're just going to leave this to go its own way and start our own case rather in Gauteng, pertinently to say that, and probably on an urgent basis to say that we've been given this information now, and now this is really troubling because this is affecting all the legislation. So we have to now sit and see what the strategy is going to be, and I invite all those toying groups, Afrikaans-speaking groups. Okay, now is your time to show that you are really behind stopping the BE and the expropriation, whatever, and put in that magnificent legal teams of yours that you have matured to a stage where they can now come in and assist to prevent further havoc that you have created now. So, people, I'm going to share this paper because this is a public document and you are entitled to have access to this. Read for yourself what the DA has lied about. They have been accomplice in all of these decisions. They've just used it as a comfortable, we'll come out with this trump card, and sorry for the pun, but we will come out with this trump card whenever it fits us, so that we can maybe get additional funding from whoever wants us to not reveal this. And unfortunately, it landed in the wrong hands for all of the politicians. Now we are going to go for the throats, figuratively speaking, not physically, but we are going to expose what has happened to our legislative processes probably for since 1994. We're going to go and investigate what this is all about, what the DA has now revealed, which they have kept quiet about for the past year and did nothing until now. What's the catch? What's the catch, DA? People, I hope that you have now realized that do not trust our politicians. The moment when they are in government, their whole attitude change. It's a new environment. There's new bosses who are manipulating them, and as you can now see, has actually happened. And I am actually questioning now whether all these groups which made such a noise about the Expropriation Act without considering that, oh shucks, we don't want the 1975 Act, whether they have not been instructed by someone above them who maybe of also funding them in the underneath the table. Just a possibility that I mentioned. Until the next time, God bless.
Liberty Fighters Network.
Liberty Fighters Network.